Welcome everyone to our ELPC Thinks webinar. As most of you know, I'm Howard Lerner. I'm the CEO of the Environmental Law and Policy Center. And ELPC Thinks is a series where we bring together legal experts, authors, environmental leaders, and community partners to forge new strategies for progress. Today, I'm joined by Elizabeth Wydra. Elizabeth is the CEO of the Constitutional Accountability Center. We will be talking about what the Supreme Court is doing this term, the impact more broadly on society, and particularly on environmental issues. This webinar is being recorded. We'll post it to YouTube. We're streaming live on Facebook, so you can share it with other people if you think they're interested and would like to catch up later on what we've done. So let's get started. The Q&A box is where you can put in questions. After a discussion between Elizabeth and me, we'll then open it up and we're going to try to get to as many questions as we can over the next 45 minutes. Supreme Court's 2025-26 sessions underway. Today, the court is hearing the tariffs case. At stake are many questions about the core balance of power between the executive and Congress, between the executive and the administrative agencies, and where the federal government has authority and where state governments have authority. We've seen the skepticism, to say the least, of the Supreme Court over the past few terms when it comes to environmental protection, when it comes to policies of administrative agencies. We've also seen a shift right now in the Trump administration. The Supreme Court and previous Republican administrations have been more driven by states' rights, leave lots of rooms for the states to do things, less role of the federal government. The current Trump administration is coming in very heavily on the side of the federal government to, if you will, overrule states. To help us unpack what's at issue today is Elizabeth Wydra. As I mentioned, Elizabeth leads the Constitutional Accountability Center. She's one of the leaders nationally working on constitutional issues. Some of you may also know I teach environmental constitutionalism at the University of Chicago Law School. So we're going to be talking today about what the Supreme Court is doing and likely to do this term, running from October until June 30th of next year. So Elizabeth, look at the big picture. How do you see the Supreme Court's jurisprudence evolving, administrative law evolving? What is this Supreme Court likely to do this term and overall to help shape or reshape the balance between federal and state power when it comes to environmental protection? Take it away.
Yeah, thank you, Howard. So I just first want to thank you so much for inviting me to be part of this conversation. It's really fantastic to be with you and to be in conversation with the listeners and participants in the webinar today. And these are incredibly important issues, both in the Midwest, where ELPC operates, but across the country. And we at the Constitutional Accountability Center, we use constitutional text and history and also statutory text and history to support progressive outcomes. We are a nonprofit, nonpartisan 501c3. And I think one of the big themes for this term, as it always is, but I think even more acutely, is balance of power. You know, we certainly see that with respect to the Trump administration's repeated attempts to grab power for itself away from Congress, certainly. We're talking about that in the tariffs case today, away from the states, as we'll see when we get to the National Guard case. Deployment of the National Guard against the wishes of states and localities, and also shifting from the people. We're also going to have this term likely a grant in the birthright citizenship cases that deal with the Trump executive order seeking to limit birthright citizenship contrary to the plain text of the Constitution. And then even within the kind of more general understanding of balance of power, we also have cases, particularly in the environmental context, that will determine whether federal or state rules apply when it comes to liability or whether state courts or federal courts will be the ones to determine liability and accountability. So there's a balance of power question between federal and state legal authority. And then, of course, we are seeing in the administrative law context really important cases this term that come from President Trump trying to fire without cause leaders of multi-member independent agencies. And those cases, I think, are going to be really big and really important and will shape the way that these long-standing but increasingly important multi-member independent agencies have been able to work for the good of American people, the federal government being able to act in the public interest, which of course, those of us probably listening and participating in this conversation believe include environmental protection.
It's every president is frustrated by, if you will, the balance of power on administrative agencies. The appointments tend to be both Democrats and Republicans. They come through the US Senate, and you get that balance where a Democratic president wishes that the FTC or the FTC would move faster in their direction. Republican president, the same thing. President Trump is really the first to try to seize the power altogether and take over what are nominally independent agencies. The other, at least to me, constitutionally amusing and in some ways appalling point is to watch the Trump administration's peculiar commandeering of the state's approach to federalism. Commandeering was a concept that came out of the Roberts Court. It was about the federal government not overstepping its bounds, in their view, under the various constitutional provisions, and commandeering the states to do things that were nominally in the state's powers, not the federal powers, and the Roberts Court saying the federal government can't commandeer the states. Well, the Trump administration's approach, which is driven very much by a pro-fossil fuels and anti-climate solutions policy, sort of throws that principle out the window. There is now a US Department of Justice lawsuit to stop the state of Michigan from taking actions for climate change solutions, even though the state of Michigan hasn't really done that yet. It's sort of being filed in advance, and the Attorney General, Dana Nessel, for the state of Michigan, has said this is based wholly on speculation of what Michigan might do as opposed to what Michigan's actually doing. The US Department of Energy and the Department of Justice are declaring that there's a national emergency that exists to force this Michigan utility, Consumers Energy, to keep running the old Campbell power plant that's not economic, it's not needed for grid reliability. It was scheduled to shut down in May of this year. And then you have the Trump administration Justice Department trying to stop Vermont and New York from having Superfund laws. I mean, this is if you will, a huge growth of, to the federal government shift to federalism away from what the Supreme Court has been doing historically. And another place that comes up, Elizabeth, and we were talking about it before, is with the major questions doctrine. And that's being presented to the Supreme Court today in the tariffs case. I know you want to say something about that. So to you.
Yeah, absolutely. But before I get to that, to your initial point about the DOJ lawsuits trying to essentially bully Michigan on its efforts to try to protect the citizens of its state, we're also seeing that kind of those threats at states and localities that are acting in a way contrary to Trump's federal policy. And as you said, that raises real federalism issues, at least the way that federalism has been understood by conservatives and including conservatives on the Supreme Court. So we'll see how that goes when those cases start to come up. In the first Trump administration, when they tried to take away some federal benefits to what they termed as immigration sanctuary cities, that did not succeed in the first Trump administration. So we'll see when they try to use threats of withholding federal funds in addition to these lawsuits to try to bully states and localities on policy points, how that goes. But yeah, so the major questions doctrine, as probably most folks know, was articulated by the Supreme Court as a statutory interpretation doctrine in West Virginia versus EPA that was used there to block environmental protection efforts under the theory that when the executive is acting pursuant to delegated statutory authority, if the executive action has major economic and or political consequences for the nation, then there has to be a clear delegation, a specific delegation from Congress about that. There are all sorts of problems with the major questions doctrine. We certainly opposed its creation and
Well, it's judicial activism in the extreme. What's the
absolutely.
major question? When the Supreme Court declares it's a major question.
Right. That being said, while I opposed the major questions doctrine and continue to think it's it is a judicial creation that doesn't have any grounding in the Constitution, the question is, how consistent will this Supreme Court be with the doctrine that they created? And so one of the big questions in the tariff case, which will have implications for all sorts of executive policy action, including in the environmental context, is will the Supreme Court apply the major questions doctrine in the context here, which is whether the president can use the International Emergency Economic Powers Act, IEPA, to enact tariffs based on these declared national emergencies, whether it's the reciprocal tariffs targeting entrenched trade deficits, or what he says is the fentanyl emergency from what he says is fentanyl coming across the border from Canada and Mexico. And so the Trump administration is trying to say this doesn't apply because it's a foreign policy context. It didn't seem this morning like there was a lot of buy-in to that. And one question that I think folks might find interesting is Justice Gorsuch asked Trump Solicitor General John Sauer, well, what if you wanted to say we're going to ban importation or put a tariff on importation of goods that are implicated by what we see as the national emergency of climate change caused by international international failure to address climate change. And so if that's a global problem that we think is causing a national emergency of climate change in the United States, could a president have tariffs and regulation of goods based on that climate emergency? And Sauer, of course, parroting the Trump administration line, says, well, we would never do that because we think climate change is a hoax. And Gorsuch said, yeah, but the next president might not. And Sauer seemed to acknowledge that, yeah, you could do that under his theory. The president could do that under his theory of major questions doctrine because it wouldn't apply because there's a foreign policy implication. So I think that the justices are probably going to apply it. And then once you apply it, it's hard to see how the tariffs survive that. But if they don't apply it, then I think there are going to be really concerning implications for the consistency of this court and its ability to look beyond a particular political agenda.
Right. When you look at major questions, think about what the facts are in this case. First of all, the case is being brought by business groups, and that certainly appeals more to Chief Justice Roberts and some of the other justices than when it's an environmental case per se being brought by environmental groups or in action by the US EPA. Secondly, it's hard to argue that tariffs don't have a massive effect on the American economy. They clearly do, and they clearly have more of an impact than certain EPA regulations and such that the court has found to be subject to the major questions doctrine. And finally, the way in which the Trump administration has applied the tariffs, which are sort of today it's on this country, tomorrow it's off, undercuts there is a widespread emergency. It makes it look much more like what to most people it seems to be, political deal making and trying to achieve various goals that are the tariffs are not the tariffs are the tool rather than the end. So I agree entirely with you that if the court doesn't apply the major questions doctrine here, then it's simply a matter of, you know, simply making political choices of what the court thinks is and what the court thinks isn't based on the whims of their political points of view or the current administration's political point of view. Where I think it also gets particularly important in the current environmental context is with the cases we're dealing with on the Campbell coal plant and other coal plants where the U.S. Department of Energy, using its Section 202C powers under the Federal Power Act, has declared that there's an energy emergency in the country and that they can therefore force the continued operation of coal plants that have otherwise been found to be uneconomic to keep operating and not especially needed for grid reliability. And if the court, in this case, limits the power of the executive to, on his own, President Trump and his administrative agencies to simply declare an emergency or put some guardrails around that, which the court is reasonably likely to do in this case, that's going to have a lot of carryover on some of the environmental issues, both as you were describing, Justice Gorsuch's question in the future about climate change, but the present debate going on with regard to the declared emergency by the executive branch to justify requiring old uneconomic coal plants to keep open, even though the utility and the state public utility commissions have all agreed to shut them down. Do you see that shift coming over time from the court, or is this simply they're going to make a decision on this case, then they'll make another decision, and there won't necessarily be a lot of connective tissue between the several?
I think we don't quite know yet. If the court applies the major questions doctrine in this case, despite Trump's invocation of these various emergencies, it will be hard to square that with, if they don't apply the major questions in the tariff case, it'll be hard to square that with when they did apply major questions in the Biden student loan case, where there was the declared national emergency of the COVID pandemic. He sought to provide student loan relief pursuant to a statute that allowed him to do that under national emergencies. And the court there applied the major questions doctrine and said the statute was not specific enough to allow Biden to engage in this student loan relief plan. And so they struck it down. So, we have the declaration of the major questions doctrine, the
Right.
application of the Biden emergency case. If it doesn't apply in the Trump emergency tariff case, then I don't see much connective tissue. If they do apply it, then I think we'll see from there.
And I'm also just going to guess, but prognosticate a little bit. The tariffs case is one that the court probably isn't going to wait till June 30th to issue its opinion.
Yes.
This is one they've put on a fast track.
Very fast
It
track.
has enormous implications for businesses and people across the country, whether it's the people who grow soy or the people who buy foods at the grocery store with soy in it. So sooner rather than later, you think so too?
Absolutely. I mean, they basically went from briefing to argument in about a little over a month, which might not seem fast to some folks, but for the Supreme Court is like lightning fast.
That's lightning.
So I would think probably before the end of the calendar year.
There's one case I want to talk with you a little bit about, the National Pork Producers case. This is a couple of years ago. The case involved a California referendum that said that pork products could not be sold in California unless the animals were raised in relatively humane conditions. Some of you know about CAFOs, concentrated animal feeding operations, where thousands of pigs and cows and hogs and chickens are confined in very, very small spaces. The referendum, which was voted on and approved by the people in the state of California, set a minimum, if you will, healthy area in which the pigs or hogs had to be if the pork was to be sold in California. And that applied to either pig producers in Iowa or Indiana, as it did to producers in California. The 5-4 decision by the Supreme Court upheld the California referendum. And what's fascinating about it is the unusual alignment of justices. There were two justices, Justice Thomas, Justice Gorsuch, and the opinions written by Justice Gorsuch, who clearly don't believe either that the Dormant Commerce Clause exists or it has a very, very narrow scope, that you can't overrule states with the Dormant Commerce Clause. They were joined in the opinion by two justices, Justice Kagan and Justice Sotomayor, who are generally viewed as being the liberal or left wing of the court, who thought that the regulation was reasonable in terms of its scope and it fit within existing balancing standards. And then they were joined by Justice Coney Barrett, who issued a concurring opinion that was pretty short, a little bit hard to follow in parts, but she comprised a 5-4 majority. I don't think there have been a lot of opinions by this court that have had that lineup. You know, Gorsuch writes the opinion, Justice Thomas, Justice Coney Barrett, Justice Kagan, Justice Sotomayor. Do you see that and other areas as unusual alignments becoming possible? Or is that just sort of a one-off case where Dormant Commerce Clause is very particular jurisprudence, and it's good if you're litigating dormant commerce clauses cases to allow the states more room, but it's not really likely to play out in other contexts? What do you think?
Yeah, so I am delighted you want to talk about this case. I find it fascinating for like
I do. I find it
yes,
apart from the serious real world implications,
yes,
just a legal standpoint, a constitutional standpoint,
yes,
this is
yes.
fascinating.
Yes, and as a born and raised California and also vegetarian, like I really like Prop 12.
There you go.
And also, and we filed a brief in this case talking about the history of the Dormant Commerce Clause. And, so again, there's so many interesting things to talk about. First, just on the merits, so the Dormant Commerce Clause is this idea that because the Constitution delegates authority to Congress to regulate interstate commerce, it necessarily implies that state laws are invalid if they discriminate against out-of-state commerce, because that would interfere with Congress's ability to regulate interstate commerce. Now, even that is a little controversial, but what the corporate interests in the pork producers case tried to do was broaden that to say the Dormant Commerce Clause prohibits state laws and policies that basically affect out-of-state commerce. That is a big shift from discriminate against to affect the behavior of out-of-state economic actors. And the majority, as you noted, rejected that attempt at expansion. And, one thing that I think is interesting in that lineup, so, we have Gorsuch, Thomas, Barrett, Sotomayor, and Kagan, that includes the three probably most publicly aligned conservative originalists and textualists, Gorsuch, Thomas, Amy Coney Barrett as well. And so, that to me, when you look at the conservatives on the other side, Alito, Roberts, Kavanaugh are not seen as quite strictly originalist as Thomas and Gorsuch, for example, and as Barrett is increasingly seen to be. So that I think is interesting. The controversy that I think is something to watch for going forward, or not controversy, but disagreement, is that the majority doesn't seem interested in what they kind of consider this freewheeling balancing test that
Right.
some find from a decision, the Pike decision, where you look at the in-state economic benefits as opposed to the out-of-state economic burdens. And the court was like, this isn't really an appropriate thing for us to be doing. And then the four justices who disagreed with that said, this is actually something we should be doing, because if that balance is incredibly out of whack, then we see that as basically approximating the discriminate against out-of-state commerce.
The interesting thing is there are actually 6 justices who say that the Pike balancing test, which has been in constitutional law for the last 30, 40 years, applies.
Hmm.
Sotomayor and Kagan and the majority and the four dissenters. So you have an opinion of 5 that upholds the California referendum, and the split views on the 5 get them to a
Right.
majority, but the thinking and rationale is sort of all over the place. And Justice Brown Jackson joins the dissenters there. And where we think it's particularly important, where she might well move,
Hmm.
is if the case involves climate change.
Yes.
Because you're going to see there are efforts to challenge state climate change action laws based on dormant commerce clause. There's been cases involving North Dakota and Minnesota, a lot of sort of red state versus blue states of saying that when states step up to take actions to limit greenhouse gases, it interferes with interstate commerce, hence dormant commerce clause arguments being made. And if there are 5 who, for whatever mixed set of reasons, plus judging by her past rulings earlier, Justice Brown Jackson joins those 5, then there are 6, if you will,
Hmm.
perhaps for different reasons, to be supportive of state actions on climate change, which may well be why the Trump administration is using other arguments such as um, national security, foreign affairs, uh, to attempt to justify stepping on Michigan, stepping on New York, stepping on Vermont from trying to move the ball forward on climate change.
Yeah, I think that's exactly right. And because you think if you have the strict originalists, who don't like the dormant commerce clause, and then you might be able to persuade some of the more moderate to liberal justices, then yeah, because that's a very 5-4, and as you said, it might even be like a 6. That's a pliable majority on that question. And Justice Kavanaugh paints, a very policy focused picture, which is that that the pork producer's opinion could encourage states to enact laws that essentially impose their values on other states. Which is kind of inherent in the federalist system, and as the majority says, we do this with state income tax laws as well. Some states have higher law income tax, which causes people to go to other states. Other states attract people by having lower income tax. So that's kind of how it works in the United States.
Yeah, well, we have a constitutional system in which North Dakota has 2 senators and California has 2 senators. On the other hand, we have a system in which California is a much bigger part of the economy than North Dakota.
Hmm.
And the state of California and consumers using their market force, in this case bolstered by policy from the referendum, do have a much bigger impact on the national economy than the state of Iowa or Indiana does. But flip side being, of course, all the states have 2 senators, and Californians rightfully complain all the time of they only have 2 senators while these other states have a lot more. Um,
As a DC resident, I'll take 2.
Fair point.
Yes.
No, this is for those of you who aren't steeped in the concept of originalism, Justice Scalia was well known for, with regard to the Dormant Commerce Clause, saying, as I look at the Constitution, I don't see the words Dormant Commerce Clause anywhere. Therefore, it wasn't in the original constitutional framers' intent, and therefore there is no Dormant Commerce Clause doctrine, period. End of case, end of story. Justice Thomas has consistently adopted the same view. The others that Elizabeth and I have been talking about, the 3 who Justice Gorsuch sort of leans strongly, I think it's fair to say, in that direction.
Mhm.
Justice Coney Barrett's jurisprudence is being developed, but she's clearly leaning in that direction. But Scalia and Thomas have been very consistent over the years in terms of saying Dormant Commerce Clause is not in the original Constitution. It's not in any of the amendments to the Constitution. Therefore, the concept has no principle in law and should not be applied by the courts. At least credit for consistency on that point. I think Justice Thomas has been pretty consistent. Elizabeth, let's talk very quickly before we get to Q&A about a couple of the big cases coming up this term before the court. We talked about the tariffs case. Do you want to talk a little bit about Chevron, the Chevron case in Louisiana, with regard to whether the lawsuits by states and localities against the oil industry belong in the federal courts or the state courts?
Yeah, so this is an interesting case again about that kind of balance of power in this respect between federal and state. And Chevron has been subject to a massive judgment coming out of the Louisiana state courts for its ravaging of the Louisiana coastline with its drilling activities. And they've tried to get out of it for a long time. They've already been smacked down by the court once in their attempt to remove the case from state court to federal court, which would have, in their view, the benefit of further delay, as well as, they hope they'll have a better chance with a federal court that maybe they think is further removed from the environmental devastation that they caused in the state of Louisiana. And their argument for why they belong in federal court is that Chevron during World War II helped process aviation fuel. And therefore, because they had these federal contracts, they fall under the federal officer removal to federal court. That is obviously a bold argument, and it's generally been a loser for them. They lost in the Fifth Circuit Court of Appeals, both at the panel and the en banc Fifth Circuit. The Fifth Circuit is extremely conservative, arguably even more conservative than the United States Supreme Court with its conservative supermajority. So the fact that they've consistently lost, I think says a lot about how bad this argument is. They summarily lost their last time they tried to remove the case to federal court in the Supreme Court. So, I think it's really a stalling tactic. I'm hopeful that it will fail again in the Supreme Court. If it didn't, then I think the implications would be huge, certainly for the environmental context when you're trying to hold someone accountable for environmental devastation, because it's essentially a get out of state court free card if you ever had a federal contract, even if it's unrelated to the wrongdoing that you're being held accountable for in the state case.
A related case where this comes up, again, these are technical legal issues of jurisdiction, is in the case involving the Enbridge Line 5 oil pipeline in the Straits of Mackinac in northern Michigan. The case Enbridge versus Nestle is before the Supreme Court. This is a case where the state of Michigan sued Enbridge to shut down the Line 5 pipeline in the state court. Enbridge moved to remove it to federal court. That then got appealed up to the Sixth Circuit. The U.S. Court of Appeals for the Sixth Circuit said that the federal removal statute has a 30-day time limit, that Enbridge waited, I think it was about a year and a half, and therefore they couldn't remove the case. They sent it back down and said, send it to a state court. Enbridge filed a certiorari petition. The court agreed to take the case, principally because there's a split among the circuits. So we're dealing with a sort of pretty rarefied legal technical issue here of whether the federal removal law 30-day time limit is applied fairly strictly or with much more flexibility. And the issue before the court is not the pipeline itself, but is this technical issue on removal. But how the court rules on this case certainly will have an impact on whether the lawsuit brought by the governor and the attorney general of Michigan proceeds in the state court or instead in the federal court, which Enbridge is seeking to do for similar reasons that Elizabeth described with Chevron. Let's take one or two more cases, Elizabeth. Either the Cotter case or particularly Trump versus Cook, which goes to your point earlier about independent agencies.
Yeah, I think just on the Enbridge case, I think it's when we talk about kind of the strategies for litigation, I want to shout out an amicus brief in that case that was filed on behalf of tribal interests. And, given that we know that Justice Gorsuch has an interest
Good.
in tribal law, and particular is sympathetic to a lot of those arguments, I thought it was a really smart, extremely effective brief about the impact of the underlying action. So it makes real in a way that I think will be appealing to certain justices like Justice Gorsuch, the consequences of the misdeeds underlying the very technical
Good
legal
point.
argument. But yeah, I think, on the question of the Cotter case, the court is asking the Solicitor General for its views on whether state or federal law will govern liability for nuclear waste, and for damages caused by nuclear waste. And there, I think it's interesting because we get into questions of preemption, and getting to kind of our earlier point about odd pairings, especially when you have originalists like Thomas. Justice Thomas has voted in what could be deemed as a progressive way on preemption, because he takes a very narrow view of federal preemption of state law. And a lot of times when state laws are more protective of interests, and here that's the argument, that state laws allow greater liability for damages caused by nuclear waste. So it'll be interesting to see how Thomas comes out on that if they do decide to take the case. Right now it's at the cert stage, but that's something to watch for in terms of the unusual pairings.
Right.
With respect to the cases coming up to the court this term on Trump's attempted firings of members of multi-member agency boards, we have one coming out of the FTC, the Federal Trade Commission, as well as Lisa Cook from the Federal Reserve. Now, these raise slightly different legal issues, but the point is essentially the same. There has been these understood protections coming out of congressional authorizing legislation that you can only fire these members of these boards for cause. Trump has not really even tried to say that here. And so what they're trying to do is rely on this 2020 case, Saylor Law, that was about the CFPB, which was then headed by a single director. And the court said that the protections for the protection of for-cause firing doesn't apply when you have a single head of an independent agency, because that doesn't give the president enough oversight. They distinguish that from multi-member agencies. So we're going to see whether they allow Trump to have that kind of interference with multi-member as opposed to single director agency heads. And that will be incredibly important for the ability of these independent agencies to function, as the name suggests, somewhat independently. Obviously, they're subject to congressional oversight. They're subject to for-cause removal. I think on those cases, while the legal points will be important, I am a little worried that the court will try to bifurcate the FTC issue from the Fed issue.
Yes.
Business interests generally in the Roberts Court have fared extremely well. The proper functioning of the Fed is very, very important to the business community. And so I think they're going to find some way to ensure that the Fed stays somewhat insulated from President Trump.
I have very much the same thinking, because the case that's coming up, the Cook case involving a member of the Board of Governors of the Federal Reserve Board, is a especially good case if you come down on the side of the independence of these sorts of agencies. The business-oriented Supreme Court justices and a number of the business-oriented groups have weighed in. They don't want any president to be able to simply trump up charges and start booting off members of the Federal Reserve. I mean, that has implications that are, in the view of a lot of people in the business community, potentially disastrous. And while they may or may not disagree, may or may not agree with the current president, if there were a president whose views were to the left, if you will, of the current president, they wouldn't want that president to have those sorts of powers to automatically reshape the Federal Reserve. How the court then, the court may be sympathetic to the independence, as you're suggesting, and I agree with you, when it comes to the Federal Reserve. Less sympathetic when it comes to the FTC or the FCC or
Mhm.
even the Securities and Exchanges Commission.
Right.
So, at least in the context of the Cook case, um, if the court comes down with an opinion that reaffirms the independence of the Federal Reserve, uh, the banking system, they would have to really do some very, surgical work to somehow say it applies to the Federal Reserve Board, but not to the FTC. And then what does that mean for the Securities and Exchange Commission that has tremendous authority, or the Commodity Futures Trading Commission? That's a hard one for the court. I agree with you. Some of the justices may be inclined to try to do that, but it's not clear where do you draw the line between, something like the Consumer Product Safety Commission,
Mhm.
then to the FTC that regulates trade, then to the Securities and Exchange Commission or the Commodity Futures Trading Commission, and then to the Federal Reserve. I mean, that's just a lot of surgical precision that's at least challenging for the court. Right, Elizabeth, wrap up. Looking ahead, where do you think the court's going this term? Um, Closing thoughts, closing ideas to you.
Yes, I think, this term is going to be incredibly important, um, frankly, for all of us in the country, because it's going to be a real test of whether the Supreme Court is going to play its constitutional role as a check and a balance, um, particularly here against the Trump administration's assertions of power and power grabs that are not, in my view, supported by the Constitution or congressional legislation. And we've seen so far on the shadow docket, the emergency docket, the court generally siding with the Trump administration. But this term is going to be when we see the actual merits of those cases instead of issues about stays or injunctions getting to the court. So the actual meat of the matter and whether the court is going to hold firm on the guardrails of democracy that are in our Constitution, that is going to be at stake in this term.
So right. Thank you all for joining us today. And thank you, Elizabeth, for your good thinking and your comments today. I entirely agree with what you just said. You're right on target. ELPC will continue to be an advocate for environmental progress, both at the state and the federal levels. At the national level, and particularly in the Midwest states, we're litigating right now before more federal and state courts than we ever have before, advocating effectively and innovating to advance climate change solutions, protect the Midwest environment, communities, and the vital natural resources here, including the Great Lakes. We'll be sharing a recording via email with all of you who attended, also hosting future webinars on a variety of topics. Keep your eyes open for invites. Please join us, and thank you for all that you do. Thank you, Elizabeth Wydra. Take care.
Thanks, everyone.